and bound over to state court. All defendants, please pay attention. I'm going to explain your rights to you today. You have an absolute right to remain silent. Anything you say regarding the facts of your case can and will be used against you. You also have a right to counsel today. As you can see, I am conducting this hearing over the internet as a live stream. It is also being recorded. That means any member of the public can log on and watch. When I ask if you understand your rights, that is what I am referring to. Those who receive a signature bond will be reset for the notice. Ms. Bridgewater, what is my reset date for the state all-purpose calendar?
Yes, Your Honor. Once again, it's going to be June the 24th.
All right, so those who receive a surety or a cash bond will be going to our state all-purpose calendar on June the 24th, whereby aspects of the case, including contact and bond, may be revisited at that time. I see that there is an interpreter on the line. Does that mean that the defense attorneys need the opportunity to go into a breakout to interview that particular client who requires interpretation?
No, Your Honor, this is Kaylee Wills. I represent Mr. Lee. I was actually able to speak with him by communicating very slowly. However, I would, if possible, like the interpreter to translate the hearing so that just to ensure that Mr. Lee understands the orders.
Are you sure you don't need to speak with him first? And just, I understand that you spoke slowly, but since Mr. Lee is here,
I'm,
may be
I'm
useful. You feel comfortable going forward?
Yes, I'm confident. We had a conversation, and we were able to communicate back and forth.
Okay. All right. Is it possible to take the interpretation case first?
Your Honor, can we do position number 10 first? This young man, he waived his presence, but they're gonna take him to the take him to Grady. We're going to let him know what his bond is, so they can bond him out down at Grady.
Okay. Can we do the interpretation case after that and then Ms. Ellwanger?
Yes, ma'am.
Okay, thank you so much. We'll do the waive case 25 CR 003277G, the case of Elton Holden. Is that the correct name?
Yes, ma'am, it is.
All right, Mr. Holden is charged with obstruction and trespass with the offense date of June the 10th. Can I please have the history, Ms. Jackson?
Good afternoon, Your Honor. Mr. Holden was not on the pull sheet when I was working, but I'm pulling his history up now for you.
Okay, we'll defer to Mr. Sirocco, and if you see anything different after he's presented, you can chime in, Ms. Jackson. Mr. Sirocco, can you give us Mr. Holden's history, please?
Yes, Judge. He has 9 cycles, DWI 2021 conviction out of North Carolina, local ordinance charge convictions from 2024 that were amended from theft by shoplifting and willful obstruction conviction 2024, criminal trespass arrest 2025, theft by shoplifting and willful obstruction arrests from 2025 and 2024 respectively, with the latter having been null pros, and there was a 2024 FTA.
Okay, please proceed with your recommendation, Mr. Sirocco.
Thank you, Judge. This incident took place on June 4th, 2025 at the Garden Inn Hotel at 6701 Shannon Parkway in Union City. Law enforcement was dispatched to a criminal trespass call regarding a male who was going around knocking on multiple doors of the location. The officers made contact with the suspect. I later identified as a defendant. He was carrying an alcoholic beverage, told to put the bottle down. When asked for his date of birth, he identified himself, but when asked for his date of birth, he refused to help cooperate there. And when he was getting confrontational, he refused to put his hands behind his back. The hotel manager there at the location confirmed that the defendant had been criminally trespassed from the location. That was on February 17th, 2025, and she provided documentation for that. A search also confirmed that the defendant was wanted on 2 failure to appear warrants. That's what the officers discovered. Given the history here, the recent cases involving obstruction and criminal trespass, and with the FTAs, the state is asking for $1,000 surety bond, 500 surety on each charge. Stay away from the Garden Inn Hotel at 6701 Shannon Parkway in Union City, and no drugs, weapons, or alcohol while out on bond.
Okay, thank you, Ms. Wells.
Thank you, Judge. Currently, his bond is set at $700, so I'm not sure why the state is asking for a higher bond, but regardless, I'm requesting a signature bond for Mr. Holden. He's 41 years old. He's resided in the Atlanta area for the past 7, 8 years. He would like a one-time police escort. He says that he has a Cash App card that is at the Garden Inn. So if he could have a one-time police escort to go back to collect any belongings or property that he might have there. I have also submitted a request for our social worker to visit him if he's still incarcerated or at the local jail by the time they receive my email and make it down to the jail.
All right, defendant's gonna receive a $10 cash fine, $5 on each count. He is to stay away from that Hilton Garden Hotel. He can return one time with a member of law enforcement to retrieve his items. He's have no drugs, alcohol, weapons, and because he is getting a cash bond, he's going to all purpose on the 24th. Is there anything additional?
Nothing from the state.
All right, sir, the interpreter, will you please state your name for the record?
It's Jason Lee.
Mr. Lee, may I place you under oath this afternoon?
Yes,
Do you swear or affirm today that you will make an accurate translation from English to Korean, Korean to English to the best of your skills, knowledge, and ability today?
I do.
Thank you. All right, and what position is this gentleman? Oh, position 12. All right, good afternoon, Mr. Lee. Your case is 25 CR 003275E, and you're charged with simple battery in this case.
예, 안녕하세요. 본인 소유권 번호는 245R32678이고 오늘 받고 계시는 혐의는 단순 구타입니다.
Did you understand your rights as I explained them earlier?
본인의 권리에 대해서 이전에 설명해 드렸는데 다 이해하셨습니까? Yes.
All right. Ms. Jackson, do you have Mr. Lee's history?
Yes, Your Honor.
Please proceed and give time for interpretation.
Yes. There are 4 cycles out of Texas.
예, 텍사스에서 4건에 대한 전과가 있고
The last arrest was April the 3rd, 2010 out of Dallas, Texas, for a charge counsel may want to waive sounding on.
그 마지막 기소된 것은 2010년도 4월 3일 날이었고 텍사스에서
And there was no disposition and there are no convictions in the GCIC.
그 조지아 그 시스템에 의하면은 유죄 판결 받은 기록은 없다고 돼 있다.
And he appears to meet the criteria for UJR through the jail.
UJR의 그 조건이 맞는 것 같다.
Nothing in addition.
그 외에는 없다.
Thank you. Mr. Nixon, please proceed.
Yes, Your Honor. Good afternoon.
Good afternoon.
This occurred on June 9th, 2025. An officer was dispatched to a fight call at 2280 Shearshire Bridge.
슈샤일 브리지의 어떤 장소로 6월 9일 날 경찰이 신고를 받고 출동을 했고
And upon arrival, the officer was met by the victim, later identified as Vilma Gonzalez, that stated her boss, later identified as the defendant, grabbed her by the neck with both hands.
거기에 도착하니까 이 사건의 피해자로 돼 있는 미스 건잘레스가 얘기를 하기로 자기 사장님이 자기 목을 쥐고 목을 조았다라고 증언을 했고
She didn't lose consciousness or faint, and the officer spoke with the defendant, who admitted he did put his hands on Miss Gonzalez's neck, but he was only, in his words, horsing around.
그래서 그 미스터 리가 그 피의자로 돼 있는데 경찰이 피의자한테 물어보니까 목을 조르긴 졸랐지만 그 장난치는 중에서 그렇게 졸랐다고 얘기를 했고
In reference to the defendant's Georgia criminal history having none, the state is recommending a signature bond through pretrial services, no further contact with the victim, Vilma Gonzalez, and no alcohol, drugs, or weapons while out on bond. And the state would ask that you sound for the victim.
그리고 그런데 조지아 주에는 유죄 판결에 대한 전과가 없으니까 본드 보석금은 보석금 없이 보석 석방을 우리는 추천을 하고 그러나 석방되어 있는 동안 그 피해자랑 절대 접촉이 있으면 안 되고 술과 불법 약물은 삼가해야 된다는 조건으로 석방을 추천을 한다.
All right. Ms. Wills, do you have any objection to the signature bond?
No, I would ask that it go through the jail as opposed to pretrial. And then, I'm sorry, go ahead. I'm sorry.
그 보석금 없이 석방하는 것은 의의가 없지만 그 구치소를 통해서 석방을 됐으면 좋겠다.
And speaking with Mr. Lee, it's my understanding that this happened at his place of employment or possible where he owns a dry cleaner.
지금 피의자랑 얘기를 해보니까 이 일은 그 세탁소 아니면은 하여튼 일터에서 일어난 일이었고
And the alleged victim is an employee, so I did inform him that she can no longer work there, and that there would likely be a no contact provision ordered today.
그리고 그 피해자는 거기에서 직원이라고 들었는데 지금 이 석방 조건이 그 여자와 접촉이 있으면 안 된다는 거니까 그 여자는 일터에서 더 이상 직원으로 일을 하면 안 된다는 것을 얘기를 해줬다.
Nothing further.
I'm sounding for Ms. Gonzalez at this time.
피해자는 불렀고 대답은 없었고.
Okay, I want to clarify one point. You're saying that the incident location is his business and the young lady worked there?
Yes, that is what he explained to me.
하나 확인하겠는데 그 사건은 일자리에서 일어났고 그리고 그 피해자라고 하는 여자는 거기 직원이라고 맞다.
All right. All right, defendant is going to receive a $4,000 signature bond at level 1 through pretrial services.
그러면은 나는 보석금 없이 보석 석방을 허락을 하겠고
He's to have no further violent contact with the alleged victim.
그리고 그 피해자라고 주장하는 사람이랑은 그 폭행적인 접촉이 있으면 안 된다고 명령을 하겠다.
And he's to have no alcohol, drugs, or weapons.
그리고 보석 석방에 있는 동안 술이나 불법 약물은 하면 안 되고
And he'll be reset for the notice.
그리고 다음 법정 기일은 통보를 받을 것이다.
Is there anything additional from the state or from the defense?
그 추가로 더할 게 있는
Do you need?
자, 질문이 하나 있는데요.
No, Your Honor, thank you.
Can I ask a question?
Yes, very briefly.
예, 짧게 해주세요.
저 아까 전과가 텍사스에서 제가 전과가 있다고 했나요?
Did you say that I have a criminal record from Texas?
That is what the history said, yes.
예, 기록서에 그렇게 나와 있습니다.
텍사스
Did he say anything else?
예, 또 다른 말 하셨습니까?
All right. Please make sure he understands he's allowed to sign his own bond.
예, 그래서 서명 사인만 하시면은 오늘 그 보석 석방은 받으실 수 있고.
All right. Best of luck to you, Mr. Lee. That concludes your case.
예, 오늘은 그게 전부입니다.
Position,
And Mr. Lee, thank you for your services today. Take care. Have a good afternoon.
You're welcome. Thank you, Judge.
Okay,
Thank you.
bye-bye. Now, can we take, this is Ms. Ellwinger's case?
can I take this position 1 through 3 so we can get him back to house? Got issues going on here.
Oh, okay, I'm trying, Ms. Ellwinger. All right, Mr. Bivens, you have 3 cases today, 25 CR 003239C. You're charged with battery family violence, 2 counts of simple battery family violence and criminal trespass. You have 25 CR 0032 3240C, you're charged with battery, family violence, and simple battery, family violence. You also have 25 CR 003249C, and once you're charged with battery, family violence, simple battery, family violence, and 2 counts of theft by taking. Do you understand your rights today?
예,
Okay, thank you, Ms. Jackson.
He has 25 cycles. The last arrest was January the 13th, 2024, out of Fulton County for battery, family violence, and criminal trespassing. He does appear to have an open case pending for battery, family violence, and criminal trespassing. That case number is 24 PI 000347. In addition to that, it appears to have an outstanding hold out of Carrollton, Georgia for larceny. The date on that warrant was January the 7th, 2025. He does have a prior felony conviction. It's in 2014 out of Clayton County for possession of tools for commission of a crime. And he does have misdemeanor convictions and sentences. Sworn in 2021 out of Clayton for disorderly conduct. He received a no contendory sentence in 2016 out of Forest Park, Georgia for driving while license suspended or revoked and possession of marijuana less than an ounce. There's an additional no contendory sentence in 2016 out of Clayton County for battery, family violence. And he received first offender treatment in 2011 out of Walton County for criminal trespassing, 2 counts, and possession of tools for commission of a crime. That case was sealed July the 6th, 2017. Nothing in addition.
Thank you, Mrs. Rocco. He has a lot of cases, so if we could maybe summarize a little bit, or, give me the flavor of them. It seems like he needs to be taken from courtroom 2 as quickly as possible. Thank you.
So, to shorten them, all of these incidents took place at the same location, 3200 Cushman Circle, one of the apartments there in Atlanta. And they all took place against the same victim, Miss Bridget Wilbon, Wilbon, with I'm not going in order here, but the
Fine.
3239C case, that was on January 9th, 2025. Essentially they've lived on and off together, but most of the time they've lived together for the past 2.5 years roughly. And on the January 9th one, they had gotten into a dispute wherein he began poking her in the forehead with his fingers, pushing her back, causing her to stumble backwards. And they got into a physical altercation for roughly 10 minutes, after which he had threatened to damage her bed and then proceeded to damage her bed frame, rendering it unusable, which is when she called 911. She sustained a visible laceration from the incident, and a warrant was issued for his arrest for that case. The April 6th incident, this is going to be actually position 3 on the calendar, this one involved, again, an argument, and the defendant started taking items from the apartment, and Miss Wilbon, the defendant kicked Miss Wilbon in the face. She flipped the couch onto her, also grabbed her belongings, including $287 in cash, her Georgia ID, debit card, and Cash App card. There was a witness there who saw this incident and observed the two arguing, stating that the defendant then started pushing Miss Wilbon. That witness's name is Miss Ashley Lang, and Miss Wilbon sustained a laceration on her mouth from this incident. Warrant was issued for his arrest there. And with respect to the oldest in time incident of the 3 here from December 15th of 24, that was, excuse me, that's position 2. And this one involved the 2 where the defendant came in and forced his way into the home and grabbed her by the neck with both hands, leaving 2 scratches on her neck, which the officers observed. As you heard, Judge, there is a significant history here. You heard about that NOLO from 2016 to battery family violence. That was a different victim, from my understanding. And you also heard reference to the open 24 PI battery family violence criminal trespass case. That was against the same victim here, Miss Bridget Wilbon. He is accused of grabbing her by the face and neck with his hands, scratching her neck and chest, and throwing her furniture around the room and into the wall of the bedroom, leaving a hole in it. That was from January 13th of 2024. We've spoken with the victim in this case. She confirmed they are no longer a relationship, they no longer live together, and they don't share children. She confirmed the events in all of the warrants. She stated that the defendant did grab her by the neck on December 15th, 2024. She says it wasn't a strangling, though. She did confirm that on the April 4th incident, which is again position 3, the defendant kicked her in the face. And as a result, she's actually lost peripheral vision in her left eye, and that her teeth are now cracked on the front and bottom, and she's going to have to get them pulled because of this. She's going to need surgery, apparently. We'll be looking into medical documentation from her with respect to any potential upgrades here. She did confirm that she received all of her items back from the defendant on the theft incident, with the exception of the cash, the $287 in cash. She wants no contact with the defendant, wants him to stay away from the residence. And I mean, this is the second reset now, but when we had spoken to her originally, she had confirmed she'd be on Zoom. We'd asked the court sound for her. You know, you've heard the history of domestic violence here. He has that prior battery FV NOLO, as I've said. And since then, he's accumulated, among a number of probation violations as well, a series of violent offenses, a series of violent cases against the same victim, including that 24 PI case from January of 2024. Then you have our cases here. This is a pattern of violence. 2024, he has not gone a full calendar year where he hasn't amassed 2 violent cases against her, including this year, and we are only in June. He poses a significant threat to her in reoffense and witness intimidation as well. This is just persistent. And as mentioned, he's also has that hold out of Carrollton for that larceny. Because of these various reasons, the state is asking for a $13,000 cash bond for position case 1 here. It would be a $5,000 cash bond total. The split would be $2,500 cash bond on the battery family violence, $1,000 cash bond on each simple battery family violence, and a $500 cash bond on the criminal trespass. For position 3, $5,000 cash bond total, $3,000 on the battery family violence, $1,000 on the simple battery family violence, and $500 on each theft by taking. And lastly, with respect to position 2, $3,000 total cash bond, $2,000 on the battery family violence, $1,000 on the simple battery family violence. And with respect to the conditions on all, we're asking for FFIB, no further contact with Miss Bridget Wilbon. Stay away from 3200 Cushman Circle, Southwest Atlanta. Surrender any and all firearms to the sheriff's office, and no drugs, weapons, or alcohol while out on bond. And if again, we could sound for Miss Wilbon.
Is Miss Wilbon present? Wants to make a statement? All right, Ms. Tucker.
Thank you, Your Honor. I would like to point out that the state presented no evidence of any type of witness intimidation from my client. Before I proceed, Mr. Bivens is 41 years of age. He is an Atlanta native. He has lived at the incident location, 3200 Crushman, for over a year now. his name along with Ms. Wilman's. They are both on the lease. He has completed his high school education, and he's currently employed at the Mercedes-Benz Stadium. He's been working there for the last 2 years. He does have 7 children. He does not have any failure to appears on his record. His children are in the area. He is from here. He's resided here his whole life. So I'm requesting a signature bond on all counts on his behalf. We have no objections to not returning to the incident location. Prior to his arrest, he actually was removing his items in regards to any damage to the property in the home. The furniture in the apartment was actually belonged to him. As I said, his name is on the lease. It was his apartment. We also have no objections to no further contact with Ms. Wilburn. So again, I am requesting a signature bond on all counts on his behalf.
All right, thank you. Defendant is going to receive for the case at position 1 a $4,000 surety bond. It'll be $1,500 on count 1, $1,000 on count 2, $1,000 on count 3, and $500 on count 4 for that total of $1,000 with the no further contact and the stay away provisions as well as the surrender of the firearms. For position 2, defendant is going to receive a $1,500 surety bond, $1,000 on count 1, $500 on count 2, with the same conditions of stay away and no further contact. As it pertains to position 3, defendant is going to receive a $2,000 surety bond, $1,000 on count 1, $500 on count 2, and $250 on each remaining count with the same requirements that he have no contact with Ms. Wilburn and stay away from the incident location. Because he has received surety bonds, he is going to all purpose on the 24th. Is there anything additional?
Nothing to say, Judge.
All right, best of luck to you, Mr. Vivens. Those conclude your cases for today. There will be additional development in the future.
Yeah. Position 6.
All right, thank you. Mr. Dawson, your case is 25 CR 003284G. You're charged with simple assault, disorderly conduct, and criminal trespass. Do you understand your rights this afternoon? Is that a yes? Thank you. Ms. Jackson?
There are no prior arrests on file, Your Honor. She does appear to meet the criteria for UJR he does, I apologize, for UJR through the jail. Nothing in addition.
All right, thank you. Mr. Nixon, please proceed.
Yes, Your Honor. This occurred on June 9th, 2025 at 1540450 Old Alabama Road. That's the Cafe Amico. The defendant approached the front end counter, picked up 2 hard plastic menu boards, and threw them one after the other toward the floor where the juvenile victim, initials A.H., was standing. Both menu boards shattered upon striking the ground near the victim's right foot, and the defendant was then observed exiting the business. The incident was observed on a CCTV camera by the officer. Now, officer has spoken with the victim. The victim is 16 years old. The victim and her mother, Ruth Hernandez, I believe she's actually on Zoom. The victim stated that the defendant had a call-in order, but his food was not ready when the defendant showed up. She made the defendant his drinks, but still had to wait on the food. Now, the phone rang and the victim answered it and tried to give the phone to her manager, and the defendant thought that the victim said something to him. The victim stated that the defendant came to the counter asking her what she said, and she did not know what the defendant was talking about and ignored him. The victim stated that the defendant continued to yell and curse at her, and then threw the menus at her. She stated that the menus did not hit her, and she wants no contact and to stay away from the property. And again, I think the victim's mother, Ruth Hernandez, is on the Zoom. Per the criminal history regarding the defendant, the state is recommending an SOB through pretrial. No further contact with the minor victim, initials AH, a stay away from Cafe Amico, that's 1540450 Old Alabama Road in Roswell, no alcohol, drugs, or weapons while out on bond, and 1 day anger awareness. And the state would ask that the court sound for the victim when appropriate.
Okay, Ms. Hernandez, I see you on Zoom. If you wish to make a very brief statement, I'm going to give you some instructions before you do so. Please raise your right hand. Do you swear or affirm the testimony you give today will be the truth to the best of your knowledge and is given under the penalty of perjury?
I do.
All right. Today is just, you can put your hand down. Thank you. I do appreciate you being here today, but I want to explain this is a bond hearing, and as this is a misdemeanor offense, the defendant here is entitled to receive a bond today. If you disagree or want to add to what Mr. Nixon just shared, that's not what's of critical importance to me. There will be other opportunities in other hearings whereby you'll be able to develop facts. What I'm most interested in is your concerns for your safety, and of course, whether you wish to have the defendant return to the property. In light of those instructions, what would you like to tell me today?
Obviously, I would not like him to return to the property of where my daughter works, him or his family, just for her own safety as well.
All right. I do appreciate you coming to court, and I'm sure that there's a victim advocate on the line who may give you some additional information, okay?
Thank you so much.
Thank you. Ms. Ellwanger, do you object to a signature bond with a stay away and no contact?
No, Your Honor, but I would ask that it be through the jail.
Oh, it won't be through the jail this time, Ms. Ellwanger, in light of the allegations, but I do appreciate that. Would you like to tell me something additional since we're not fully in agreement?
Yes, Your Honor, I can just tell you about my client. He's 48 years old. He lives in Alpharetta and has lived here 13 years. He's a podiatrist with a practice in Marietta. He lives here with his wife, who is also on the call, and his 3 children, ages 9, 8, and 5. He has never had any interaction with law enforcement, Your Honor, and that is why we're asking for the UJR through the jail. But no issue with the staying away from the restaurant or the named victim.
All right. Defendant is going to receive a $3,000 SOB through pretrial services at level 1. It's going to be $1,000 on each count. He is to stay away from that location, have absolutely no contact with that minor victim, have no alcohol, no drugs, no weapons, and the case will be reset further notice. Is there anything additional?
No, Your Honor.
All right, best of luck to you, Mr. Dawson. That concludes the case for today. There will be additional development in the future. Ms. Ellwanger, does that conclude your business today?
It does, Your Honor.
Take care. Have a wonderful afternoon. Bye-bye.
Thank you.
All right, who do we have next?
Dawson, number 5.
All right, Mr. Dawson, your case is 25 CR 003272E. You're charged with criminal trespass and damage to property and just plain criminal trespass. Do you understand your rights today? Is that a yes?
Yes.
Thank you. Ms. Jackson?
There are 20 cycles. The last arrest was June the 7th, 2025, with the city of Atlanta for driving while license suspended or revoked and knowingly driving a motor vehicle on a suspended or canceled or revoked registration. There is no disposition for that arrest. He does appear to be on probation in Fulton County. That case number is 15 SC 137944 for theft by receiving stolen property and obstruction of an officer and driving without a valid license. That disposition date was August the 24th, 2016, 2 years of confinement and 8 years of probation. He does appear to have an additional open case pending in Fulton County. That case number is 22 SC 180726 for aggravated battery and aggravated assault and cruelty to children and battery. He does have prior felony convictions. One in 2014 out of Clayton County for possession of a firearm during commission of a felony and possession of tools for commission of a crime and theft by taking. And apologize. And there is an additional one. Oh, there are additional charges. I apologize, Your Honor. And criminal damage to property in the 2nd degree and 2 counts of burglary in the 2nd degree. And there was another one in 2014 for theft by receiving stolen property, one in 2012 for theft by receiving stolen property. And there are misdemeanor convictions, one in 2020 out of Clayton County for criminal trespassing, one in 2020 out of Forest Park, Georgia, for fleeing or attempting to elude an officer, one in 2016 for driving without a valid license and obstruction of an officer, one in 2015 out of Byron, Georgia, for possession of marijuana less than an ounce, one in 2014 out of Clayton County for battery. And he does appear to meet the criteria for UJR, a level 3, nothing in addition.
All right, thank you. Mrs. Rocco?
Thank you, Judge. This incident took place September 6th, 2024 at 732 Jones Avenue Northwest in Atlanta. Law enforcement responded to a vandalism call placed by Miss Latanya Barnett, who reported that her child's father, the defendant, had damaged her property. Law enforcement made contact with her. She explained that the defendant, who's also her ex-boyfriend, had come to her residence and gotten into an argument with her on the patio. This argument escalated when the defendant walked down the steps with a knife and then proceeded to slash both of her passenger side tires on her vehicle. The defendant then entered the victim's home, emptied her refrigerator, threw food and items around, causing a mess. And before departing, he also struck her Ring camera that was on the exterior of the house, damaging it, and was then identified from his driver's license photo. As you've heard, quite the history here. Criminal trespass conviction from 2020. I'd harp on as well the entering auto, theft by taking conviction from 2015, and the burglary in the second, criminal damage to property in the second, possession of firearm or knife during the commission of or attempt to commit certain felonies and other theft charges from 2014. His ag assault, battery, substantial physical harm case that was ultimately dead docketed from 2020, and his open case, the aggravated battery, family violence, and aggravated assault, family violence. That is a different victim, but it is another one of his children's mothers, where it's alleged he beat her to the point of facial disfigurement. I saw as well, and I don't believe I heard it mentioned, but he appears to be wanted out of Fairburn for larceny as well. We've spoken with the victim in this case. She stated they are not in a relationship anymore. They do no longer live together, and they do share that one child. She confirmed the events in the warrant, and she no longer lives at the location, so we won't be asking for a stay away here. She and the defendant have not had contact since this incident, and there's a transfer of the child through the defendant's mother. She had to get her tires replaced at a cost of about $200. She wants to continue having no contact and transferring the child through the third party. I don't believe she's on the line, but if the court would sound for her when appropriate, please do that. What we have here really is a family violence related damage to property case. And that's consistent with his history of property damage and interference with property convictions, his prior and present cases involving violence and family violence. And consequently, he poses a risk of reoffense to her and a danger to property within the community as a whole. So because of that, the state is seeking a $4,000 total surety bond, $2,000 for each count for him to complete FFIB, have no further contact with Latanya Barnett, surrender any and all weapons to the sheriff's office, and no drugs, weapons, or alcohol while on bond.
Is Ms. Barnett present, wishes to make a statement? Hearing none. Ms. Tucker?
Yes, Mr. Dawson is a 30-year-old Atlanta native with an 11th grade education. He's in the process of getting his GED. He's not currently employed due to a disability he sustained after being shot. He actually is scheduled to have a surgery to have a rod placed in his leg this week. As you can see, he came into the courtroom with crutches, so he's still working through that. As a result of the disability and not being employed, he would not be able to afford $3,000 surety. He doesn't have any prior failure to appears on his record. He has ties to the community. He has 3 minor children here. So we are asking for a signature bond on his behalf, if not possible, $1,000 surety bond, if the court will allow.
And just briefly, he does have FTAs in his history, one from 2016 and one from 2014.
All right, defendant's gonna receive $1,000 surety bond, 500 on each count. He's to have absolutely no contact with Ms. Barnett. They can continue to coordinate transfer of their child through a third party. Additionally, he's to have no drugs, no alcohol, no weapons, and he is also going to all purpose on the 24th. Best of luck to you, Mr. Dawson. That concludes your case at this time.
Position number 4, Ms. Bradley.
Ms. Bradley, your case is 25 CR 003271Y. In this case, you're charged with simple assault, family violence, and criminal trespass and damage to property. You understand your rights today?
Yes.
Thank you. Ms. Jackson?
There are 18 cycles. The last arrest was October the 29th, 2024, with the City of Atlanta Police Department for simple battery family violence. Does appear to be on probation in Fulton County. That case number is 19 SC 165970 for aggravated assault. That disposition date was October the 11th, 2019. 3 years of confinement and 17 years on probation. Also, there appears to be an additional open case pending in Fulton County. That case number is 24 CR 007416 and the letter Y for simple battery and criminal trespassing. There are prior felony convictions, one in 2019 out of DeKalb County for financial or transaction card theft, one in 2018 out of DeKalb County for theft by shoplifting, one in 2014 for aggravated assault. And there are misdemeanor convictions, one in 2019 for cruelty to children in the 3rd degree and giving false information to an officer. It's an additional one in 2019 out of DeKalb County for disorderly conduct. And there was one in 2017 out of DeKalb County for pointing or aiming a gun or a pistol at another. And there was a nolo contendere sentence in 2016 out of DeKalb County for criminal trespassing. And does appear to meet the criteria for a UJR level 3, nothing in addition.
Thank you. Mr. Sirocco, please proceed.
Thank you, Judge. This incident took place yesterday at 55 Hilliard Street, Southeast Atlanta. It's Flipper Temple Apartments. Law enforcement responded to a dispute call placed by the victim, in this case, Miss Angeline Bradley, who reported that her granddaughter, the defendant, had damaged the front door to her apartment. The officer made contact with her, the victim, who explained the defendant who had used to live with her, became upset about Miss Bradley now having temporary custody of her 14-year-old grandson, who was recently released from juvenile detention. Miss Bradley explained that when the defendant's son's probation officer advised it was acceptable for him to go out with his friends, she allowed this, and then the defendant became upset over this and then came to her apartment. She did not allow the defendant access to the building, told her to leave, but someone let her in, and then she got to her door, starting to knock on it, demanding entry. She was told to leave by Miss Bradley. And at that point, the defendant kicked the door in, got in Miss Bradley's face, and began cursing at her, calling her names. The officer also observed that damage to the door, the hinges, and confirmed that it could no longer be locked due to the severity of the damage here. It was completely kicked in. The defendant was positively identified from a previous incident on February 13th of this year when Miss Bradley had contacted police to have her removed from the apartment. As you heard, number of convictions here, a number of cases on that aggravated assault from 2019. That was also part of the one with cruelty to children in the third, for which she was convicted. It was a different victim, involved a kitchen knife, and it was in front of who I would believe, based on the ages here, would be her grandson that she was upset about in this case. You have that pointing, aiming gun, pistol at another, 2017 DeKalb, aggravated assault, 2014. And that open case with the battery, family violence, and criminal trespass and damage to property, that's a different victim whom she scratched and destroyed the flat screen TV of. She was given a $1,000 good bond by Judge Morrow in that case. We have spoken with the victim here. She is the grandmother of the defendant. She confirmed they don't live together anymore and that the incident location is her residence. She confirmed the events in the warrant, explained that she and the defendant have been fine since this incident. She states she's not in fear and is okay with contact. We would ask that the court sound for her when appropriate. However, we are not okay with contact in this, given the recency and several other factors that I'll get to in a second. But we have listened to the jail calls here, and she did. The defendant placed a call to the victim in this case and states, "I know I didn't touch you, but I did kick the door in," because they were discussing why she was here. So that's an admission. Given the violence here, the history of violence, multiple aggravated assault convictions, the open battery, family violence, and the criminal trespass and damage to property case, and what with this not being the first incident where police were called to the apartment because of the defendant, with the former being to remove her, she posed a risk of reoffense to Miss Bradley. And as such, the state's asking for a $6,000 total surety, $4,000 on the simple assault family violence, $2,000 on the criminal trespass, for her to complete FFIB, have no further contact with Angelin Bradley, stay away from Flipper Temple Apartments at 55 Hilliard Street in Atlanta, and no drugs, weapons, or alcohol while out on bond.
All right, thank you. I'm gonna sound for Miss Bradley if she's present and wants to make a statement.
Yes, ma'am.
No, not you. The other Miss Bradley. All right, hearing none, Miss Tucker.
Thank you, Your Honor. Miss Bradley is a 30-year-old Atlanta native. She's currently enrolled in a theology program. She's not currently employed and does not have income at the moment. She was the primary caregiver for her 14-year-old before the recent incident, and now the grandmother, the other Miss Bradley, has temporary custody. We are asking for a signature bond for this incident, if not the lowest possible surety bond, considering she is not currently employed, and there were no injuries sustained in this incident. We have no objections to her not returning to the incident location. However, we are requesting that she be allowed to have contact with her grandmother, because they are family and her child lives there. We are just asking that there is no violent contact in the future.
And I just want to confirm the offense date for this is April the 10th, correct?
That's correct, Judge.
Oh. Defendant is going to receive a $1,500 surety bond, 1,000 on count 1, 500 on count 2. She's to have no further violent or harassing contact with the alleged victim in this case. Have no alcohol, no drugs, no weapons as a condition. Is there anything additional from the state or defense?
No, Judge.
All right, Ms. Bradley, best of luck to you. That concludes the case for today. There'll be additional development in the future.
Thank you. Number 9, Ms. Fletcher.
Ms. Fletcher, good afternoon. Your case is 25 CR 003273F. You are charged with criminal trespass in this case. Do you understand your rights?
Yes.
All right, Ms. Jackson.
There are no prior arrests on file, Your Honor.
Thank-
She appears to meet the criteria for UJR through the jail, nothing in addition.
Thank you, Mr. Sirocco.
Yes, Judge. And I have the same. This incident took place on June 10th, 2025 at 3478 Lakeside Drive, Northeast Atlanta. It's the AMLI Lennox apartment complex. Law enforcement got a phone call from the one of the property managers there requesting assistance regarding a dispute between a resident and guest. The officer made contact with the parties where a security officer explained that a man and a woman had been involved in a physical altercation, and there was a dispute over the female guest dropping her house keys down the elevator shaft. The property manager wanted to issue the defendant a criminal trespass warning, but the defendant was trying to remain. She was hesitant to leave here and continued to argue with her boyfriend and the staff. The officer repeatedly told the defendant to leave the property. She refused to comply, became vulgar in her language and arguing with staff, kept rolling up her car window up and down when the officer was tapping on it, telling her to leave. And ultimately, she attempted to leave through the back entrance, but was unable to exit. She just went to the main gate and refused to then leave when the officer opened it for her, instead driving between the driveway between two buildings on the property. Again, continuing to refuse to leave, and she was ultimately placed under arrest. The state would consent to a signature bond through pretrial services here. Stay away from AMLI Lennox Apartments at 3478 Lakeside Drive, Northeast Atlanta, and no drugs, weapons, or alcohol while on bond.
Thank you. Ms. Tucker?
Yes, Your Honor. We are also requesting a signature bond on behalf of Ms. Fletcher. She's 26 years of age. She's been residing in the Atlanta area for some time. She has no criminal history. We have no objection to not returning to the incident location, as well as the other recommendations of the state.
All right. The defendant is going to receive a $5,000 signature bond through the jail. She is to stay away from that location, have no alcohol, drugs, weapons, and she will be reset for the notice. Is there anything additional from the state or the defense?
No, Judge.
No, Your Honor.
All right. Best of luck to you, Ms. Fletcher. That concludes the hearing for today.
Number 11, Ms. Ingram.
Ms. Ingram, your case is 25-DR 003297B. You're charged with battery and simple battery. Do you understand your rights? Ms. Jackson, will you please proceed?
There are 33 cycles. The last arrest was October the 9th, 2020 in Fulton County for simple battery. There was no disposition for that arrest. And there are prior felony convictions. It's one in 2016 out of Florida for fraud, one in 2012 out of Florida for robbery, one in 2009 out of Florida for battery felony, and one in 2001 out of Jefferson County, Georgia for burglary, and one in 1993 out of Florida for robbery and obstruction of an officer. And there are misdemeanor convictions. There's one in 2018 out of Florida for petty theft, one in 2012 out of Florida for possession of drug equipment, and there was an additional one in 2012 out of Florida for a charge counsel may want to waive sounding on. And she appears to meet the criteria for UJR level 3, nothing in addition.
All right. Thank you, Mr. Nixon.
Yes, Your Honor, this occurred on June 10th, 2025. Officer was dispatched to a call at 121 Cleveland Avenue, Southeast, at the Exxon gas station. Upon arrival, the officer observed the victim, Celestine George, seating on the curve behind a MARTA bus. She stopped. She was bleeding from her right cheek area, stating that the defendant struck her in the face with a stick. The defendant was standing in front of the bus stop. The defendant stated that nothing really happened and she does not know why the victim's face is bleeding. Apparently alcohol was involved. The victim stated that the defendant charged at her with the stick and swung at her face. The officer then went inside of the gas station and asked the clerk if they could find the footage of the incident. The clerk was able to find the footage. The footage showed both the victim and the accused or the defendant were verbally arguing at the bus stop, and then it showed them pushing for a few seconds, and the victim went back to the curb behind the bus stop. But then the defendant went in front of the bus stop, grabbed a stick, approached the victim, and swung the stick at the victim, causing a laceration on the right cheek of the victim. Your Honor, you've heard the criminal history, including the 2020 simple battery arrest with a different victim, as well as the Florida violent arrests, including the aggravated battery on law enforcement. Going back to from 93 to 2012 and 2014, due to the defendant's aggressive nature, the violent history, as well as the violence in this case, state is recommending a $5,000 surety for the battery, $1,000 surety for the simple battery, no further contact with the victim, a stay away from 121 Cleveland Avenue Southeast, that's the Exxon gas station there, anger awareness, and no alcohol, drugs, or weapons while out on bond. The state would also request that the court sound for the victim in this case.
Is Ms. George present, wishes to make a statement? Hearing none, Ms. Wells?
Your Honor, I would ask that the court follow the recommendation of pretrial, and that is the signature bond for Ms. Ingram. She is 53 years old. She's resided in the Atlanta area for the past couple of years. As was stated by the state, this was a situation where there was, it appears, a mutual combat, but my client was defending herself. So for those reasons, she's also unemployed. And so again, I would request a signature bond.
All right. Defendant's going to receive $1,000 surety bond, $500 on each count. She's to have no contact with the alleged victim in this case and stay away from that location on Cleveland Avenue. Have no alcohol, no drugs, no weapons, and she's going to the all-purpose calendar on June the 24th because she received a surety bond today. Is there anything additional? All right, best of luck to you, ma'am. That concludes the case for today. Who do we have next?
Number 16, Ms. Williams.
All right, Ms. Williams, your case is 25 CR 00327888. You're charged with driving with a suspended license, driving with a suspended registration, and having no insurance. Do you understand your rights today?
Yeah.
All right, Ms. Jackson.
There are 13 cycles. The last arrest was July the 12th, 2019 in Fulton County for a probation violation. There's one prior misdemeanor conviction listed in the GCIC. It's 2015 for driving without a valid license. And she appears to meet the criteria for a UJR level 1. Nothing in addition.
All right, thank you, Mr. Nixon.
Yes, Your Honor, this occurred on June 10th, 2025, while patrolling near the intersection of Martin Luther King Jr. Drive in Bolton. Officer conducted a GCIC inquiry on a 2006 silver Ford Crown Victoria. And upon receiving the results, the officer was notified that the vehicle did not have valid insurance and its registration was suspended. The officer proceeded to initiate a traffic stop on the vehicle and made contact with the driver identified as the defendant. The officer informed the defendant of the reason for the stop, operating a motor vehicle without valid insurance and with a suspended registration. A subsequent GCIC and CIC inquiry through Fulton County's communications revealed that the defendant's driver's license was suspended due to multiple violations, including several failures to appear and prior convictions for operating a vehicle without insurance and driving with a suspended or revoked license. With regard to the criminal history, several arrests for driving without a valid license, even one null pros in 2017, but 2015, 2016, 2019, then a 2015 conviction for driving without a valid license. I have several no insurance convictions with regard and suspensions with regard to defendant's history here. And as such, the state is recommending $500 surety for driving while license suspended or revoked, $250 surety for the suspended registration, and $250 surety for the no insurance charge, as well as no alcohol, drugs, or weapons while on bond.
Ms. Wells, do you object to a signature bond to the jail and a no driving unless she has a valid license?
I do not. Thank you.
All right, defendant is gonna receive $1,000 signature bond through the jail, 500 on the first count, 250 on each remaining. She's absolutely not to drive unless she has a valid license issued by the state of Georgia, as well as registration and insurance on the vehicle she operates. She's to have no alcohol, drugs, weapons, and she will be reset for the notice. Is there anything additional? All right, best of luck to you, Ms. Williams. That concludes your case.
Number 13, Mr. Lovett.
Mr. Lovett, good afternoon. Your case is 25 CR 3281H. You're charged with possession and use of a drug-related item and criminal trespass. Do you understand your rights today? Is that a yes?
Yes.
Thank you. Ms. Jackson?
There are 64 cycles. The last arrest was January the 10th, 2022 in Fulton County for a failure to appear. There are prior felony convictions, one in 2009 for possession of cocaine, one in 2008 for possession of cocaine, one in 2005 for robbery, one in 2003 for possession of controlled substance, an additional one in 2003 for possession of controlled substance with the intent to distribute, and he received first offender treatment in 1997 for theft by receiving stolen property. That case was sealed July the 6th, 2017. And there are misdemeanor convictions. One in 2019 out of DeKalb County for criminal trespassing. An additional one in 2019 out of DeKalb County for possession and use of drug-related objects. One in 2017 out of DeKalb County for criminal trespassing. One in 2016 out of DeKalb County for criminal trespassing and giving false information to an officer. And one in 2015 out of DeKalb County for criminal trespassing. One in 2014 out of DeKalb County for criminal trespassing. One in 2013 out of DeKalb County for criminal trespassing. One in 2011 out of DeKalb County for criminal trespassing. And one in 2008 for criminal trespassing. One in 2000.
That's good, Ms. Jackson. I think he's got a lot of criminal trespass. What is the recommendation from pretrial?
A level 3, Your Honor.
All right, thank you so much. All right, Mr. Nixon?
Yes, Your Honor, this occurred on June 9th, 2025. Investigator Clark was conducting a property check at 349 Decatur Street, Southeast Atlanta. While conducting the property check, he observed multiple people loitering by laying and sitting on the property, consuming alcoholic beverages. Where there were multiple no trespassing loitering signs posted around the area. He then made contact with a male later identified as the defendant, who was sitting on a power box at the location with an open container of Steel Reserve. The defendant did remain upon the property after being notified to depart the premises. The store owner then provided the Atlanta police case number, which stated that the defendant was previously criminally trespassed and released on a copy of the citations by Officer Dixon at the time. That was May 21st, 2025. The defendant was subsequently arrested, and then an inventory search was conducted in which the officers found multiple syringes, one clear glass pipe with multiple black marks, and residue. With regard to the criminal history, you heard, Your Honor, 65 cycles. To sum it up, 17, I counted, criminal trespass convictions, 8 FTAs, and another additional 5 criminal trespass arrests, all here in Georgia. As such, the state is recommending a $500 surety for the criminal trespass, $500 surety for the possession and use of drug-related objects. Stay away from 349 Decatur Street, Southeast Atlanta. No alcohol, drugs, or weapons while out on bond, as well as alcohol drug evaluation treatment.
All right, thank you, Ms. Wells.
Your Honor, Mr. Lovett is 48 years old. He is a native of Atlanta. He's currently residing with his sister, and he is unemployed. And so I would request a signature bond on his behalf, or the lowest bond that the court is willing to order.
Defendant is going to receive a $10 cash bond, $5 on each count. He's to stay away from that location and have no alcohol, drugs, weapons. And because he's getting cash, he's going to all-purpose on the 24th. Is there anything additional? Best of luck to you, sir. That concludes your case. Who do we have next?
Number 8, Evan, 24.
Mr. Evans, your case is 25 CR 003280C. You're charged with loitering and prowling. Do you understand your rights today?
Yes, ma'am.
All right, Ms. Jackson?
There are 14 cycles. The last arrest was June the 26th, 2024 in Gwinnett County for a probation violation. Does appear to be on first offender probation in Gwinnett County for burglary in the first degree. That disposition date was February the 26th, 2024, and the term is for 10 years. Does appear to have an additional open case in DeKalb County for loitering or prowling and obstructing an officer and criminal trespassing. He has one misdemeanor conviction that was in 2023 out of DeKalb County for criminal trespassing. He appears to meet the criteria for a UJR level 3. Nothing in addition.
Thank you. Mr. Sirocco?
Thank you, Judge. This incident took place yesterday at 1081 Woodland Avenue, Northeast Atlanta. It's an apartment complex. Law enforcement was dispatched to a call regarding a male wearing various items of clothing who was cutting or prying the screen off of a unit at the location. While en route, the officer observed a man matching that suspect description and detained him. The officer made contact with the caller in the case, Mr. Alex Petty, who was in his girlfriend's apartment across the unit, and took video footage of the defendant prying or cutting the screen on the exterior window in an attempt to enter the unit. The officer then examined said unit and saw that that window, that screen window, had been forcibly pried. There was damage to it. The defendant initially claimed he was visiting a friend and admitted to knocking on a window, but denied trying to gain entry. He stated he actually admitted he didn't live at the complex, and then stated that he had previously stayed in the unit that he was trying to gain entry to here when it was unlocked, that he's never had a key, and that he's never been on a lease for the unit. He admitted that he did try to pry the screen open and cause the damage, and was placed under arrest. As you heard, several related convictions and cases here, with that burglary in the first conviction from 24, that there's a criminal trespass conviction from 23 that was also at an apartment complex just a few miles down the road from this location, and a series of arrests for criminal trespass, 2024, 2023, 2021, also a burglary in the second arrest from 2022 that ultimately wasn't presented to the grand jury out of DeKalb. The defendant has a history of related property offenses ranging from burglary to criminal trespass. We don't know the identity of the owner of the unit, so ultimately we couldn't charge criminal trespass here, but this offense was committed at a residential address. So with his history here, there is a risk of reoffense, and for that reason, the state, along with his 2023 FTAs, there's 2 of those. For those reasons, the state is seeking a $2,000 surety here. Stay away from 1081 Woodland Avenue, Northeast Atlanta, and no drugs, weapons, or alcohol while on bond.
I'm sorry, what was that amount, Mr. Sirocco?
$2,000 surety, Judge.
Oh, 2,000, thank you. Ms. Tucker?
Mr. Evans is 36 years of age. He's been in the Atlanta area for over 6 years now. He is currently homeless, and he's not employed. He's just been working, doing community service at a shelter. Due to his status as unemployed with no income, he wouldn't be able to afford a surety bond. So we are requesting a signature bond on his behalf. He does have some recent FTAs, however, they were due to him being incarcerated. He had no intention of missing any court dates. So we are requesting a signature bond on his behalf or the lowest bond that the court would grant at this time.
Defendant is gonna receive $1,000 surety bond. He's to stay away from that location on Woodland Avenue, have no alcohol, drugs, or weapons. And he is gonna be reset to state all purpose on the 24th. Is there anything additional?
Nothing on the stage, Judge.
Best of luck to you, Mr. Evans. That concludes the hearing today.
Position number 15, Mr. Took.
All right, Mr. Tooks, your case is 25 CR 003276C. You're charged with simple battery family violence. You understand your rights today?
Yes, ma'am.
Thank you, Ms. Jackson.
There are 6 cycles. The last arrest was August the 27th, 2020, with the City of Atlanta Police Department for simple battery family violence. There was no disposition for that arrest. Does have 1 prior misdemeanor conviction. It's in 2013 for theft by shoplifting. And he appears to meet the criteria for UJR level 2. Nothing in addition.
Thank you, Mr. Nixon.
Yes, Your Honor. It looks like the incident date is June 24, 2024. The victim in this case is 29-year-old Tamisha Jackson. Ms. Jackson reported an incident of assault to Atlanta police on June 24, 2024. Jackson stated that she and the defendant, her living boyfriend, were involved in a verbal dispute over guys flirting with her. Now, during this dispute, Jackson stated the defendant pushed her to the floor, causing the back of her head to hit the edge of the couch. Jackson stated she yelled she was calling the police and said the defendant fled the scene. The defendant had not returned to the location when police arrived. Jackson did not exhibit any visible injuries, but advised to the responding officers her head was hurting. In 2020, at the same incident location, the defendant was physically arrested on the scene for simple battery, family violence for assaulting Jackson. That's per the criminal history. The 2020 simple battery, family violence, it was against the same victim. I believe DA's office did decline to prosecute, but the defendant pushed Miss Jackson into a wall in that particular case. Regarding the propensity for violence and violence against this same victim, the state's going to go ahead and recommend a $2,500 surety for the simple battery family violence. No further contact with Tamisha Jackson, no alcohol, drugs, or weapons while out on bond. FVIP, a stay away from 1124 Wiley Street Southeast. I think that's apartment B202 in Atlanta, and the state would request a court sound for the victim when appropriate.
I'm sorry, and her name again was?
Tamisha Jackson.
Is Ms. Jackson on the line and wishes to make a statement? Hearing none, Ms. Wills, please proceed.
Your Honor, I would request a signature bond in this case. This case is from last June of 2024. Per the state's admission, the 2020 case, this office declined to prosecute my client in that case. And so I would ask that that not be used against my client since the state chose not to go forward. My client states that he does own his own business. He has 3 children that he supports. He has a GED as well as an associate's degree in business from the Metropolitan College. He has not had any contact or communication with Ms. Jackson for quite some time. He does not reside at that location.
Defendant is going to receive a $2,000 signature bond at level 2 through pretrial services. He's to have no contact with Ms. Jackson. He's also going to take a 1-day anger awareness course, have no alcohol, drugs, weapons, and will be reset for the notice. And he's also to stay away from the address on Wiley Street. Is there anything additional? All right, best of luck to you, sir. That concludes your case. Who do we have next?
Position number 7 is a waiver.
Position number, I'm sorry, which one?
Number 7 is a waiver, and position number 14 is a waiver.
Okay, so we'll do 14 first. The case is Mr. Daniel Mack, 25 CR 003282C. He's charged with theft by receiving and stealing acquiring a license plate for the purpose of concealing a vehicle back in March of 2024. Ms. Jackson, can I have Mr. Mack's history?
There are 26 cycles. The last arrest was May the 30th, 2025 with the Georgia Department of Corrections in Hartwood for felony theft by shoplifting. Still disposition for that arrest. He does appear to be on probation in Fulton County or either under sentence. That case number is 22 SC 183920 for aggravated assault and robbery. That disposition date was June the 21st, 2023, and the term is for 6 years. He does have prior felony convictions. It's one in 2025 out of South Carolina for possession of a stolen vehicle. The details of that conviction was not listed in the GCIC. It just stated that he was convicted on March the 19th, 2025. There was one in 2014 out of South Carolina for a federal chartered financial institution crime, and he does have misdemeanor convictions. One in 2023 out of South Carolina for driving while license suspended or revoked. One in 2020 for 3 counts of disorderly conduct. One in 2019 out of South Carolina for a DUI and giving false information to an officer. One in 2018 out of South Carolina for driving while license suspended or revoked. One in 2010 out of South Carolina for driving while license suspended or revoked, and possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Thank you. Mr. Nixon?
Yes, Your Honor. This occurred on March 13, 2024. Ms. Catherine Scott responded to the College Park Police Station and reported her vehicle tag was stolen. Ms. Scott advised that her tag was stolen from the rear of her vehicle, which was parked at 2480 Old National Parkway. That's the Quality Inn there. The officer responded to the incident location, reviewed footage of the incident, and noticed a black Chevy Malibu entering the parking lot of the location, parked behind Ms. Scott's vehicle. An unknown male subject exited the driver's seat of the Chevy, removed Ms. Scott's tag, and fled the scene shortly thereafter. And during the investigation, the officer checked the flock safety cameras and noticed Ms. Scott's stolen tag on a rear of a Hyundai sedan. Now, the officer, Robertson, with the South Fulton Police Department, attempted to stop the vehicle, and the male driver exited the driver's seat of the Hyundai and fled on foot. Officers were not able to apprehend the male subject, but the Hyundai was removed from the scene and impounded. The officer obtained a search warrant for the vehicle and located Ms. Scott's stolen tag attached along with the cell phone in the stolen vehicle. While processing the vehicle, there was a beer can in the cup holder near the driver's seat. The beer can was swapped for DNA and sent to the GBI to be tested. And the officer was also obtained a search warrant for the cell phone and noticed that it belonged to the defendant. And on May 5th, 2025, officer was notified by the GBI that the identity of the DNA was the defendant's. As per the criminal history, noted a 2024 FTA, 2024 probation revocation, as well as previously mentioned, the defendant was still on probation when this crime was committed. Per also the 2025 assault batteries in the second degree out of South Carolina, along with the 3 warrants from the Atlanta Sheriff's Office for probation violation, another Atlanta probation violation, and College Park warrant. As such, per the history and the facts in this case, Your Honor, the state is recommending $1,500 surety for the theft by receiving and $1,000 surety for acquiring a license plate for purpose of concealing identification. No further contact with Catherine Scott. No alcohol, drugs, or weapons while out on bond, as well as an anti-theft course. And the state would ask that the court sound for the victim when appropriate.
Right, is Ms. Scott present? Okay, Ms. Wells?
Thank you, Your Honor. Again, this case did occur last March. I would request a signature bond. My client is currently being held on 3 separate probation violations, so he will not be released regardless of the bond that's issued. He does report that he could work at Small Wonders as a carpenter and that he has 5 children that he does support.
Defendant's gonna receive $1,000 surety bond, $500 on each count. Have no contact with the alleged victim, last name Scott, had no alcohol, drugs, or weapons, and he's going to SAP on the 24th of this month. All right, let's take the next way to take the case. Can we turn off the YouTube, please, momentarily?